Child support is our topic today. Good morning, good afternoon, or good evening, or even good night, depending on when you're looking at this video. I am really excited that you will be attending court to observe child support cases and maybe apply, understand some of the material that you've learned in the child support chapter. We start out with the premise that the parents are the natural guardians of their children by law, so they are obligated to provide the necessities for their children. And you will understand now that there are statutory guidelines that provide a percentage in some cases and how that's calculated to determine what a parent should pay for their child. Prior to, however, the guidelines being adopted by the states, the court had to undertake the task of determining child support based on various factors. Necessities was one of those. And if you recall from the McGuire case, that concept of what a necessity is can vary from person to person and therefore from judge to judge and court to court. So in that case, we were dealing with a wife who was only provided bare necessities, including having to go to the outhouse. So, and then the question was, what are necessities? Necessities for children may be different than necessities for adults in some situations. So, quite frankly, the child support awards were varied throughout the country, state, even within the same courthouse. And when I began practicing law, we had a judge who was born during the Depression and lived sometime. And he really thought $100 was a substantial amount of money, and it was to him. And so his awards were very low, $50, 25 a month, 100 a month was for him a substantial amount of money, and he probably lived a frugal life. Well, of course, as judges came on the bench who were younger, who had different concepts, you had higher awards. And so when he was on the bench with judges who were newer and used to a more affluent lifestyle, the awards differed even down the hall within the courthouse. And in Hinds County, there were 4 judges, so you would have 4 different amounts, which the judges, based on their experiences and what they considered to be necessities for the children. Well, in 88, the federal government recognized that there was a need for standard uniformity in child support awards. Cases were coming to the courts now, substantial number of cases where divorces had increased, the number of single parents who were coming for support, that unwed mothers mostly, to file child support awards against the father. Then the calculations had to consider there were state and federal benefits that were available to some children as time went on, TANF benefits, food stamps, medical insurance. And then there were also benefits of tax benefits, like head of household credits. And so the court needed, well, the federal government recognized that with all of these changes, economic changes, there was a need for uniformity in child support awards. So there would not be situations where you saw a high child support award in one case, and then in a very similar circumstances, there may have been a substantially lower child support award. So the effort was to balance, to have uniform standard child support awards. On page 397 in the Beauchamp v. Palmer case, here's a good history of how the child support guidelines came into effect starting in 1988. And so it required that by 1989 that all states would adopt child support guidelines which presume that based upon the guidelines and the calculations resulting from the guidelines, that the child support award was a reasonable award and in the best interest of the child. And so once again, we have a presumption in the law. And we understand now that presumptions can be overcome. But with regard to the guideline amount, it was presumptively in the best interest of the parties. It also was necessary to affect court efficiency so that the court could handle a lot of cases in a short period of time, applying a guideline amount without having to go through tedious evidentiary hearings regarding what the income was spent on, and various other things. So the states came up with their own guidelines, and there are really three models that resulted. The income shared model, and that is the most common one that you will find in the United States. I'm not sure exactly how many states apply the income shared model, but it is the model that the majority of states use. So the goal in developing this guideline is to provide a child with the same amount of money that they would have, and I say the child would have the benefit of the same amount of money that they would have had their family been intact and had they had the benefit of both parents spending money providing for them. So the court looked to consider the income of each of the parents, and then they accumulated data which showed what intact families spent on their children. They went through what the cost of housing, what the cost of clothing, utilities, all of those considerations. And they looked at that data. And for you all who are really math-minded, you probably could see how it's calculated based on their parents' income, the needs of the child based on the figures that they impute for clothing and housing. And then they came up with a model that took all of that into consideration and allocated each parent to pay for that. But of course, they had to also consider that the non-custodial parent was not spending money like the custodial parent was, because the custodial parent had transportation costs. They had also time that they were not being compensated for. They had to, make decisions, use gas to take the children during the week, and maybe the non-custodial parent only had the children on weekend, which you wouldn't use much gas. So all of those considerations were looked at, taken into consideration, and then allocated as what a custodial parent should pay and what a non-custodial parent should pay. And then based upon how much each parent made, that amount was prorated. Once they combined the income, then they looked at what parent made this amount and what parent made that amount, and then they prorated it. And so that is the income shared model, a little more complicated than the next one, which is the percentage of obligor income model, which is what's called a flat percentage rate. And in essence, the guideline provides that the judge will look at the non-custodial parent's income and apply a percentage to that income for one child, two children, depending on how many children. So let's look at here in 1989, when I came on the bench, the guidelines were promulgated in 1989. The flat percentage rate for one child was 17%. So if a parent, non-custodial parent, was obligated to pay, the court would look at their income, and if it was $1,000, I'll round it out, then the parent was obligated to pay 17% of their adjusted gross income. Now, in 1984, I believe, the guideline amount was later reduced to 14% of adjusted gross income. So in the flat percentage rate, the court looks at the non-custodial party's income. They take deductions that we'll talk about that are required by law, and then they apply the percentage for one child. If it's two children, there's a percentage, as you see here, 3 children and 4 children. And literally in 1989, I was applying 17% of adjusted gross income. I really do think the income model is a better approach, but in Mississippi, we have the flat percentage rate, and it was fine, 17%. It's workable, but literally in the legislation starts normally in July. I was applying 17%, and then we got our legislation update that said child support guidelines have been reduced to 14% for one child. So literally the first part of the year, anybody having a child support award would have received 17% of adjusted gross income. And then after July, we had to start applying 14% of adjusted gross income. And the amounts are 14% for one child, 20 for 2, 22 for 3, 24, and 26 for any amount of children over 5. Now, I don't know why. I think 14% from a personal perspective is low. My understanding, and I don't really have the actual factual information, but what we heard trying to figure out why the support was reduced was that one of the legislatures had a child who went to court and had to pay child support, and that person felt that it was too much, and that it should be less. And so legislation was introduced to reduce it, and now we're at 14%. I really do think that was unfortunate, and maybe people differ depending on whether you're receiving the child support or you're paying the child support. The The third model is the income shares model. Only 3 states use this model. And as you can see, it's in the explanation, it's rather complicated and therefore it's not really used. They use a lot more data and calculations than they do in the income approach. Okay, so in our case that we have, the Volscian case, the court is dealing here with the income shares model. And so the formula required the judge to come up with the combined adjusted income for both parents. There is a schedule that the judge, once they come up with the amount, adjusted gross income amount, then they determine the support. What amount should this child receive based on that guideline for the child's support necessities? Then the judge divides that amount to prorate it based on the parent's income. So the court would base, if a parent had $5,000 and another parent's income was $1,000, then obviously one parent would pay, what's that, 4 or 5? 25%, 20%, math wasn't my great subject in school, 25% more than the other parent. So it would be prorated there. And then the court would look at any other expenses that the child may need, and also use a calculation for those expenses. Now, there are situations, the judge, we're talking about necessities. So in these calculations, they are looking at what amount will, and this is not based on individuals, it's based on the entire state. What amount should be allocated for necessities to support a child? And so that's, once the court has a calculation that reaches that amount, then the court does not necessarily apply the guidelines. And so what I'm saying is, if you've got a parent who is making $500,000 a year, if you used the guidelines calculation percentage-wise, that child may be receiving way more money than what is required for them to be given their necessities. All right. And so there is a cap that is put for the judge to consider when applying guidelines. And when I say consider, basically the guidelines are not automatically applied where you have very high income, and likewise where you have very low income. If you have a parent that's, and we're talking adjusted gross, so we're taking out income expenses we'll talk about from that amount, you could be talking about as little as $1,200. And if you're using the percentage approach, then 14/12 is somewhere probably in the area of $160. I hope my math is right. And then that may be substantially low to provide the necessities. So we have an amount at which the guidelines are capped for high earning parents and low earning parents. So here, if the combined adjusted actual income exceeds the highest level in the schedule, which is what happened, the judge may use its discretion. So we go from the presumption to the court's discretion in determining the child support award. Now, this amount that the court determines should not be lower than what the highest amount of the awards, the child support award, would be. So, for example, if the highest amount calculated under the guidelines that a parent would pay would be $2,000 a month, then the court's discretion does not allow that judge to reduce the support by $2,000. Reduce the support below $2,000. So in the Boschen case, there was an increase. There was an initial award of support, and then there was an increase in the award. The judge, when they went back to court, awarded the non-custodial parent $1,400 a month. Well, in this case, that's what happened. The maximum amount and the guideline amount was $1,040. And because he was such a high earning parent, it went to the discretion of the judge really as to what that amount should be. But John's argument is that the judge should still use the guidelines in determining the support by capping that amount. That should be the amount that it takes to provide the necessities for the minor child. And he argues that that's the reasonable amount because he goes beyond the upper limit cap. And he says, well, if you don't really buy that, then the amount should not be discretionary, but should be based on the percentage of increase per $100, because the guideline amount was increased per $100. It went up every time a parent's income went up $100. Then there was probably, and I don't know the exact amount, but I'm just, for an example, maybe $5 per every $100 it would increase. And he's saying, well, that's what the judge should use to make that determination. And obviously, when he calculated it out, it was less than $1,400 a month. All right, so here on appeal, the court did not buy his argument. They found that the guidelines provided the presumptive minimum, that it actually provides a minimum amount of necessities. So the court can, in its discretion, use other factors to determine the income. So the point here is there's a presumption that the guideline amount is correct. Once the income exceeds the guideline amount or is below, then really it becomes the judge's discretion as to what the child's support should be. The judge should consider whether or not the guidelines should apply though. So for example, if it were the guideline amount were maxed out at $10,000 a month and the person made $10,100 a month, then the judge could quite reasonably say, because of there's only $100 more that he's making that sent him over the guideline amount will still be what the judge is looking at. So once again, presumptions, that's the key is that the amount of child support within the guideline amount is presumed to be in the best interest of the child and the parties, and any amount, and that guideline can be overcome. All right. All right, and because the federal legislation not only provided for the guidelines and the states to become uniform in the child support awards, it also provided mechanisms by which the court could enforce the judgments. And there are state enforcement remedies and federal enforcement remedies. Now, With regard to the state, you got the civil contempt, where the court can hold someone in contempt and actually incarcerate them until they pay. And that's based on the fact that the court has entered a judgment, a child support judgment, to pay an amount, normally on a monthly basis. The obligator has refused to comply, and the court may then incarcerate them until they comply with the court's judgment. And of course, there's the old collections of garnishment. So the state has various means of collecting. The federal government also now has enforcement power through withholding federal privileges. And for example, passports and certain licenses you cannot get if you have not paid your child support, if there's a child support judgment that has been enrolled through the federal program. And then instant seizure of funds is another one, and this is administratively. So unfortunately, unfortunately, I think there are really some due process concerns. The cases that I would deal with pretty much on a regular basis was where a license was suspended, and let's say a driver's license, a truck driver. And the truck driver may have been stopped, pulled over. All of a sudden, they don't have, they run their special license and it's been revoked. And so then they're arrested, possibly, or they lose their jobs. And so, and they had, in some instances, no idea. And so I really have questions and issues as to the fairness and due process. The other one that happens a lot is that if the person has an income tax refund, the federal government will seize that. So the person's looking for their income tax refund, and it has been seized by the government to satisfy child support award. And then any bank accounts that they find. Now you say, well, what is the federal government's interest? These are normally cases, but it can be private cases, as if you enrolled it in the federal program. But most of these cases involve where the recipient of the benefits is receiving federal benefits. Okay, because when they receive the federal benefits, as we will see in the the case after, then you sign over your rights to any child support or any amount you receive for the minor child. And so now the federal government is stepping into the shoes of the child support recipient, and they can use their powers to collect that money. So like I say, I do have, especially it's just hard when you see somebody lose their job because they didn't pay their child support. In some instances, the process issues may be there. And so in essence, and it can be dangerous when you get pulled over, as you have seen on TV, a few cases where the person was irate because they didn't understand why their license had been suspended or whatever. And they were irate with the police, which is not a good thing. So that enforcement mechanism really raises for me some concerns. The Mule case is interesting because the father went another situation where the father's income substantially increased. and the mother came in, petitioned the court for more child support. Well, the court increased it. Once again, he was a high wage earner, and the support was increased to $3,092. $1,780 of it wasn't to be used for really the child's necessities. It was to be put in a trust for the child to use when they went to college. And in the state of my notes though, in the state of Tennessee, the age of majority had been revised to 18. So college is normally after 18. Now we have a child who's using, who's where the father in this case is paying child support for a child who is emancipated over the age of majority. So the father appealed it based upon the calculations that it's, although the judge used the guideline amount, it was really more than the child needed for necessities, and that $1,780 is being collected and not being used during the minority, as I said. So here we have a case where the judge is really looking to apply guidelines almost at the high income amount. And the judge also was deviating from the guidelines because he was allocating certain amount of money from, to the future care of the child when the child wasn't even a minor. So the court, the first thing, let me just back up a minute. We have the guideline awards. And so that is based upon the presumption that the guideline amount is in the best interest of the child and should be used. And of course, income changes over the years. Hopefully people will finish school or move up in the career and they'll make substantially more money. And here, that's what happened. And in order to have a change, the court to enter an order which modifies the child support, the court has to find that there is a substantial and material change in circumstances. And of course, we need that because otherwise the courts would be inundated when people got $500 raise or any amount that somebody says, well, you should now be paying $25 more, $50 more. So the standard is that the change needs to be substantial. And it could be income has increased substantially or decreased. Needs could have increased, someone's sick, or there's a special need that has arisen. But the standard in order to have the child support modified is that there's a substantial and material change in circumstances. In this case, he started out with $30,000 and then it went to $280,000, almost $300,000 at one point. So here he capped out at the highest amount of income that the guidelines applied to. So here we go with the judge having discretion and deviate from that percentage amount. And the court said, yes, in this situation, he is deviating in that he's requiring money for college. And the court is saying, yes, but look, what the policy we consider is that justifies that you can award a parent to pay college before they even get to college, is that children of separated parents should have the same economic and social advantage of an intact family. So if the parents are living together and he was making $300,000, then the court is considering they would have a fund and make preparations for the child to go to college. The equal protection argument obviously comes up to obligate one parent to pay support if they're not married versus someone that the court doesn't require parents to pay and provide college expenses if the parents are married. So what are the factors? Because when the court makes decisions deviating from the guidelines, court has to make an on the record finding of the basis of that deviation. That's not what happens in the guideline amount. Remember, guidelines are presumed correct. So the court doesn't have to explain it, just has to explain the calculation. And now with AI and so forth, you just put it into a calculator or AI and it spits out the amount. But if there's a deviation, the court has to consider and make a finding on the reasons for the deviation and the guideline amounts then as to why they adjusted upward or down. Those reasons are, these are just four, but there are anything the judge can think about to be a reason. Difference in incomes, where one parent has so little income and really can't make any more, then their differences in income may require the court to deviate. Look at equitable considerations may come into place depending on why is the person's income so low. Did they contribute to somebody's business and maybe they weren't married, they didn't get the benefit, and that's a high income and earner and they're stuck making a very low wage. There are all kinds of equitable considerations, whether there is college expense, and then special needs of it, where we'll see the case where the child had ADD. What his argument, equal protection violation, the court said no, public policy of the state is to provide children with college education whenever possible. So the parents can be required to pay for both college tuition and child support if they are a minority at the time. And in Mississippi, that happens a lot because of the majority of age is 21. So clearly that falls within the time range of a minority. However, in Tennessee, the court also said, well, he could go ahead and start contributing based on the fact that he is such a high earner that, and it's not going to adversely affect him. And that way the child will have the funds to go to college. If they were an intact family, they probably would have had some type of college trust, and therefore the purpose of, child support is to provide the children with the not only the necessities, but also those things that other children would have had there been an intact family. In Mississippi, as long as the child is showing an aptitude to attend college, and then the court can deviate and require payments in addition to child support for college tuition. And what I mentioned earlier, what are college tuition expenses? Books, computer, dorm, bedding, social clubs, matching bed linen for the dorm with the new roommate. It keeps going. And I hear, sororities, fraternities, it keeps evolving. This is the case when we talk about special needs or circumstances that cause a deviation. In this case, the mother put the child in private school, and she put one of the children. So here, it was I assume for the court considered that this wasn't like, okay, I'm going to impose this expense on him, because she only put one of the children there. The child had ADD. It was shown the child was not doing well in public school. The child improved in private school. The mother paid for the expenses for 2 years. And then the senior year, she said, can you pay? I'm really having a hard time. And dad says no. So there was the material change in circumstance based on the child's needs. The court found, and then the father had the ability to pay it. And so he could pay it. He said no. And he couldn't pay all of it. Looks like he only was required to pay $8,000. Court considered that factor, but it was really in the court's discretion once the material change in circumstance was filed, once there was a showing for a reason to deviate from the guideline because of the child's special needs on that. And so here the court basically had two statutes that weren't in conflict necessarily, but one said that the court could make decisions based on support and education. And the other just said that a lady amendment allowed for deviations. And they did allow for deviations from the guidelines, but initially the court said that the guideline amount should apply. And then they later came back and said that there can be a deviation from the guideline if the award was unfair. So here, and I have done it, and I do it, or I did award private school tuition payments. I'm very cautious about that, because it's also a political issue, although that's not a reason that I would make a decision not. But once you start awarding the private school tuition, you have to really consider that it can be substantial, and much of the private school tuition that is paid is really financed. So in essence, parents are themselves, this is my opinion, obligating themselves to pay money in excess of any guideline amount. I've seen, it's up at $30,000 a year. So the court can deviate from the private, can deviate from the guidelines or the private school tuition on these factors. And this is what happened here from the special need of the child. She had attended, mom had paid, and it was only 1 year. I think it may have been different if she was looking at 4 years, that her decision to put the child in private school. And normally if I have awarded it, it would be where the parties separated, the children were in private school already, and that would cause a disruption for the children to be removed from private school to go to another school, maybe a public school on that. Religious considerations. These are the considerations the court may decide, may use. Step parent, this Mississippi does not have a statute that allows for step parent. It does not obligate, Mississippi does not have a statute that obligates step parents to pay child support. But in this case, and there are some states where there is the obligation for the parents to pay child support. And that this might be time to take a brief break. Okay, so we're back. Mississippi has a step parent has no obligation to pay child support in Mississippi. That obligation was discussed in the Stahl case, a state of let's see, I'm sorry, the state of Washington, where there is a statute for the parent to provide the step parent to provide the support. Just basically the wife filed for divorce. He was out the house October of 81. In March of 82, she applied for assistance and was, I guess, received. It looks like that's what happened. She received benefits. And this could have been TANF, food stamps, Medicaid. From March of 82 to February of 83, when the divorce was entered. And that's when his obligation would have ceased under an application of the statute. And he then would have been, as a step parent, even though he wasn't living in the home, but as a step parent, obligated to pay for that March of 82 to, I'm sorry, that should be 83. I apologize. That should be 83, the period from when the divorce was entered. And so the court had, yes, he had that obligation as long as he was legally married to the mother. And so in Mississippi, there's no common law or statutory duty for step parents to support their children. However, remember equitable estoppel, equity, and there may be a situation there where a step parent would be obligated to pay, but we don't have step parent, an obligation for step parent to pay. This is the situation where we have the equitable payment, an equity claim here. And the court applied equity. A man, they were married, they had 2 children, then the wife had an affair while they were together, and she got pregnant, she had a daughter, and it turned out the daughter was not his. He found out about it, the adultery, moved out. And it looks like he went, traveled, but he always paid and supported the 3 children and had a relationship with them, including the one he knew was not his. So and this happens, they entered into, I'm assuming, a no-fault divorce, agreed to pretty much everything, including the support, and that the child he would pay and support the girl, which wasn't his biological child. Well, then, as happens, he remarried a year later, and then a year later he filed to terminate for support of the child. The equitable estoppel factors consider voluntary acquiescence of the mother, voluntary acceptance of the obligation, and reliance. And that's what you always need in any kind of equitable argument. You got to have somebody relying on it. And here, reliance on the support and the actions of the party you're seeking to obligate. Here, the mother relied on the support. The child, there's some indication that they talk about the child and, this father relationship that's being created. And also, is it a month? I mean, this was going on for 3 years. And so the court did find that there was an equitable that equitable estoppel should apply in this case. Now, the court discussed in detail the Miller case that they relied on, where the father or the man was required to pay for the child. And I really agree with the concurrence. The facts were quite different. We had a situation with a man that was just intent on having a relationship, looked like with someone that really wasn't that interested. And the father, he came in, he tried to get custody, he did all of those things. It's really different in this particular case. There was, I believe the concurrence said, a significant difference in the Miller case. And I agree. The facts here, that they are different. And maybe the results should be the same, but I do the reliance on Miller. That's a little concerning to me, like the concurrent opinion said. And equitable estoppel should be invoked cautiously. We should not, it's very cautious in this case and obligating the someone who's not related to pay and support a child. And then there's this concept, and it's probably true now. It's the court's effort. It says in the majority's effort is to try to spare or try to protect the girl so that she has a father. She has a family. She's has, the same person, father that her siblings has. It's more of an intact family, even though they're divorced. And the court says, yeah, she's gonna find out probably that he's not the father. She's gonna probably find out who his father is. And it's just going, it's not going to protect her like the majority opinion seems to say. And they also talk about the response. Yeah, what about, explain to us why the natural dad, at least go through why that person is not obligated to pay and not paying, and what you did to have that father pay the support. But I have to agree, now things are different with DNA and biology, and mostly the biology wins out. Children want to know who their biological parent, most children, are, and eventually they will find out. So I think the concurring opinion had some really good points here. I'm not saying that the decision, and I guess that's why they were concurring and wanted to make these points, was wrong, because he did have a length of time, long time, and really it was precipitated mostly by the remarriage. The wife, who's like, why are you paying money for this child? It's not even your child, and we could be using it, and so forth. Okay, I think that will get us up through child support. Just understand, Mississippi has its own child support guidelines, and for the Mississippi law, you can look at the statutory amount there, 14%, and the statute provides that amount goes up after that. All right, so I hope this will be helpful and also help you when you are in court in the child support court. Judge Singletary is looking forward to you coming and to discussing anything regarding support. He was a chancellor for 20 years prior to becoming the master. He retired, and so he just started doing child support course. So he has a lot of knowledge there. So please engage him. Unfortunately, we can't say what's going to happen. You never know what's going to happen in court. So just hopefully you will be able to see a case and ask questions and learn something about child support. All right, I will sign off.